Good evening and welcome. You're watching Breaking Views with me, Sanket Upadhyay, the only show where we get you all the views so that you get the complete picture. On today's show, a very, very important issue. Perhaps the Supreme Court has taken the first step towards removing a law, an archaic old law, which should have been relegated to the dustbin long, long ago. It does not exist even in the United Kingdom, from where it originally came. In India, it has been used as a political tool, so says the petitioner in the case in the Supreme Court. Now the Supreme Court has said that pending review, this law should be paused. And since it has been paused, all the people who have been affected by this law can approach respective courts for relief. But then while all of this was happening, the law minister of the country, Kiran Rijiju, says there's a Lakshman Rekha and that Lakshman Rekha should not be crossed. Do picture this. Between 2015 and 2020, there were about 550 arrests under sedition cases all over the country by many state governments also. Only 12 were convicted. So then we ask the most fundamental question. In sedition, who is crossing that Lakshman Rekha? Imagine 550 arrests and only 12 convictions. Who is crossing that Lakshman Rekha? The court or the various governments who are using this, in the words of the petitioner, as a political tool. Let me start our face-off number one. We've got Vrinda Grover, an advocate for the petitioners in the Patricia Mukim and Anuradha Bhasin case, the sedition case. We also have Aditya Shankar Prasad. He's the managing partner at Prasad and Associates. Thank you very much to the two of you. Ms. Grover, I want to begin with you first. First of all, how do you view this decision by the Supreme Court?
I think it's a very important and significant order. It is a big blow in favor of civil liberties, freedoms guaranteed by the Constitution. This is not just an archaic colonial offense. It is an oppressive offense. And it is a pre-constitution offense which was meant to arm the colonial state. It has no place under the constitutional republic that we live in, where this has been used by all governments to choke the voice of citizens of the country. And I think the Supreme Court has stepped in and brought it in line with the constitutional freedoms that we must enjoy. And this is all about speech. It's all about, and personal liberty was at stake because people were choosing to comment, speak. And that provision cannot exist under our constitutional scheme anymore.
Okay. Mr. Prasad, you see, when a comment like "don't cross the Lakshman Rekha" is made, one really sits and wonders who has crossed that Lakshman Rekha. I mean, you look at the central government's appeal, the central government's position in the court. They are first okay with the idea of sedition, then they say that we'll go for a review, and then when the court asks that should we pause the existing cases, the government says don't pause. And then when the court pauses them, then you've got the law minister saying, well, there is a Lakshman Rekha. Don't exceed the Lakshman Rekha.
Well, Sanket, thank you for having a discussion on this. I think this was long due.
Welcome.
You see, the law that was promulgated and has been part of centuries in this country is to be reflected on the times in which this law was brought into picture. Sedition at that time was sedition against the British Empire, as we all understand. However, today, when this debate has political overtones and can be seen in very different perspectives by either political parties, I don't want to name any political party. But today, I think this law needs to have a revisit, and the Supreme Court has done a very beautiful job of taking a relook of this law, whether this law deserves to be there on the statute book or not. My fundamental point is that when you have cases related to sedition, to oppress political opponents, these are cases which can be attributed to malified reasons. And that goes for any political party. I would not like to name any party, But if the law minister has made a statement that there must be a Lakshman Rekha, that must be an affront of the view of the government. But as a practicing lawyer, I must tell you that there are cases in which there are regressive literature. There are cases where there is very outspoken, outlandish views which people of either ideology can talk about. However, the law does take its own course, but I personally believe.
No, but Mr. Prasad, if I may, the upgrade or review the last time when it happened of this sedition law was in 1962, where certain contours were set, that if there is a call to arms or an attempt to bring to harm the integrity of this country, at that time it can be used. Right now we see a very generous sprinkling of this law, that you want to keep someone in prison, slap a sedition case.
I fully agree with you, Sanket. I think this law needs to be done away with. In today's time, we do not have any scope for a law which calls for sedition. You see, there might be disaffection, there might be discontentment, there might be difference of opinion, but certainly not sedition, because we are not living in an age of any empire.
Correct.
It's a democracy. We cherish our democracy. There are fundamental freedoms. Article 21 is enshrined very well in the Constitution of India, and every citizen of this country has a right to express opinion or a dissent or whatever. There is a more fundamental question. That fundamental question is that in certain cases where there is a massive disaffection against the state, how do you tackle such situations? There has to be some kind of I would say a reasonable approach. Maybe the Supreme Court can lay down certain guidelines as to what would constitute sedition and what is not sedition.
Vrinda Grover, how would you respond? You see, right now the problem is that you've got a central government which would like to remind everyone that the law is still there. It has been paused, but it's still there.
Right, but for all practical purposes, and the effect of the order that was passed today is both for future arrests, present investigations, as well as trials and prosecutions stand halted. Any policeman, state government, central government, court that does not adhere to this is violating the order of the Supreme Court. Insofar as this provision is concerned, I think we as citizens need to, think about what is this democracy about, what is the state, what is the Constitution? Why can I not have disaffection? Let us pause on that word. Am I, as a citizen of India, required? And please understand, sedition talks about government established by law, not about India.
The country.
There are two different concepts in law and in political theory. I am not required as a citizen to have affection towards government established by law, not in a democracy where I have the right to ballot.
Correct.
How does anybody know who I voted for? I don't have to have affection. The only red line that any penal offense can draw is on incitement to violence. You have more than enough provisions in the Indian Penal Code and a whole host of
and we don't need the sedition law.
Anti-terror draconian laws. There is no dearth of legal provisions. What is happening through this is a chilling effect. Let us not deny this. Any comedian, a cartoonist, person tweeting, you go in and then you don't know whether you will get bail or not.
Correct.
Every government has misused. There can, or rather I would say used.
Correct.
There can be only one use of the sedition law.
And it has been misused by one and all. All state governments have pressed this.
And to silence. I just want to comment on this Lakshman Rekha that seems to be getting the buzz today. Can I just briefly comment? First, a preliminary comment. Can we expect those who take oath on the Constitution and hold posts to junk patriarchal, misogynistic phrases like Lakshman Rekha and adopt language that is in keeping with the constitutional spirit that we must live by? That could be perhaps a first step. Insofar as which organ of the state does what. When I learned the law, and as I continue to be a student of law, the only forum that can judicially review the constitutionality of a provision is a constitutional court, be it the Honorable Supreme Court or any high court in this country. The court has in fact said If you want to review, please re-examine. But you can't.
Till then,
you
yeah,
can't
you
be
can't,
playing,
you can't keep pressing these charges while you're reviewing.
And in fact, their written submissions say that they believe Kedarnath is good law. They have not asked for repeal. They are saying we are re-examining.
Right.
We don't know what they will come up with.
Ms. Vrinda Grover and Mr. Prasad, thank you very much for joining us with your views. We also have now the former Solicitor General of India, Mr. Hari Salve. Thank you very much, Mr. Salve. First question, how do you see this order?
The Supreme Court I was seeing the order and I was, confess, I've only seen it as reported, not as written. They seem to have recommended to the governments not to precipitate the sedition cases. And I believe the Attorney General also accepted in court that the sedition law is being misapplied. I mean, I've also seen some of the cases where sedition law has been applied. I strongly feel that, speaking for myself, I've always been a critic of the sedition law. I feel two things which have no place in our law and which need to be done away. Sedition has to be brought down to a call to arms, and the defamation law should go. Criminal defamation. Defamation has to be civil. So, but that's one point of view. The other point of view is that today, and I see the force of what the solicitor is saying, that today many times sedition gets bound up as one of the elements of terrorist cases. So that part has to be preserved, where it is a violent call to break up the integrity of India. Those are cases of sedition.
No, Mr. Salve, so from what you're saying, am I to understand that you don't oppose the sedition law, but you oppose its misuse?
As we say, it's a call to arms. If you we have cases where the call to arms is to oppose the very idea of India. Those cases normally are cases where people are of an extreme ideology and given to violence. And that's why the Supreme Court had read it down. Unfortunately, once again, it has sort of drifted back into, and the current times, what we have seen, what I have seen of some cases, is shocking that criticism of a politician is considered to be sedition. And this is shocking. Whether it be the Hanuman Chalisa, whether it be Arnab Goswami calling the Congress chief names, or whether it be somebody calling the Delhi chief minister names, it may be distasteful, but how does it become sedition?
Right. Mr. Salve, would you then say that this law was structurally flawed? I mean, yes, we are trying to, debate on whether something else is required or not, but do you feel that you can't build on a law which is structurally flawed?
No, not always. Look at it this way. When the British were governing India, a criticism of the British masters questioned their way of ruling India and their presence in India. Now you can't, that ship sailed in 1947. So we do not have that construct anymore. Secondly, the principles of what is considered free speech have grown enormously. And you've seen the vocabulary of debate in public life has become acerbic, not just in India, even outside India. You see in England, where otherwise it was people spoke in very measured tones. Today you see the opposition leader calling the Prime Minister using words which were never used before. In Australia, you heard recently the Australian Prime Minister called the leader of the opposition in some very sharp tones. So this vocabulary of debate has changed, but that has nothing to do with sedition. Sedition is when you're opposing the very identity of the nation. And it has only relevance today because we do face a threat of existence.
Correct.
Or a challenge to our existence from radical forces. So if it is kept as what is called a call to arms, if somebody is trying to round up and use speech to round up people to have an uprising against the state. Using it in few and far between cases like that, one can see the good sense. But beyond that, to say that abusing the government or criticizing the government, however harsh the language, amounts to sedition is a nonsense.
Absolutely. So that's a strong word that you said, basically using this as a political tool by all governments. And you're right, it's not just BJP, but we have seen in recent cases many governments pressing the provisions of the sedition law. My final question, Mr. Salve, the law minister says that a Lakshman Rekha must be respected. Your views?
These are all the delightful debates of a democracy.
Short and
Lakshman Rekha, the Lakshman Rekha is not cast in stone. It moves from time to time.
All right, all right. Thank you very much for joining us, Mr. Salve. Short and sweet reply on the Lakshman Rekha comment. But we also have Dr. Abhishek Manu Singhvi, Rajya Sabha MP of the Congress Party. Dr. Singhvi, my first question, again, how do you look at the Supreme Court pausing sedition proceedings in the country?
Well, Sanket, I think it's an extremely creditable, supportable, very desirable judgment. I would fully support it. It's, of course, an interim order. But there are 2 or 3 facets I want to very quickly summarize for you and your viewers.
Sure.
One, the government has always opposed this in the hearings. It has never said, look, we are prepared to stop it. We are prepared to stop taking action. We are prepared to suspend it. Number 2, it has taken 3 adjournments, each time when the court had fixed categorical dates for hearing. Number 3, it perhaps tried, and I think the court turned it on its head, the 4th time to say, look, this is an adjournment by another name. We will look into it, leave it to us. The legislature we will bring into it. We all understand the meaning of such woolly, broad sentences. When the legislature, what the legislature, how many at your sweet will, 1 year, 2 years. I think that is too vague. And along with that, they opposed court intervention strongly. So given all this, I think the court did an excellent thing. And remember one thing, the court has to act. No government of any political color, including past BJP governments or non-Congress governments, have had 753 uses or arrests or wrong arrests on a conviction rate of 12 in these years. The figures are published by all of you. Now, the point is not that sedition law is there or is on the book. The point is how you have misused it. From the Mewanis of Gujarat to the travel to Assam, to the comedians, the stand-up comedians, the satirists. You as a journalist, I can assure you, you may not say it on television, would have to look twice over your shoulder because of this fear. And there is another aspect to it, let me tell you. Today, in 95% cases, the prosecution which files the case against Abhishek Singhvi or Sanket Upadhyay knows that they will get bail within 2 months, 3 months, 4 weeks, 6 weeks. It's the harassment in those 4 to 6 weeks which you can't prevent because your remedy is ex post facto. There is nothing preventive, it is curative, and that curative is good enough to harass you endlessly. So I would like the court, and this is something the court has not done, it should do it in final hearing, is to say that look, when you find there has to be some penal element which will deter police officers from filing frivolous, vexatious, superficial cases. Because today is no use saying, I will file it, देखी जाएगी बाद में वो निकल जाएगा तो क्या फर्क पड़ता है, 2-3 महीने तो सड़ेगा, उसको नुकसान तो होगा. तो इसलिए this needs to be clarified by some penal that look, if you start registering such cases on very low thresholds, when you can do 20 other provisions and you do the sedition straight away, then you will be penalized as an officer of the police, which will deter. Deterrence is there as a preventive measure. Very important, not merely as a curative intervention.
Okay, sure. But Dr. Singhvi, you know, this has instantly become political also, where the law minister is now saying that the Congress should be the last party to speak on sedition as it has misused it the most. And also says that the Lakshman Rekha between the government and the judiciary must be respected.
I think the law minister is wrong on both counts. He's so grievously wrong that he doesn't even realize it. Sometimes you're so wrong that you don't realize that you are totally wrong. First of all, the Lakshman Rekha is crossed by a government filing 753 arrests, or the Lakshman Rekha is crossed by a court which gives you 3 opportunities and then stays it. You decide for yourself. Is this Lakshman Rekha or is it a self-serving boundary drawn to protect yourself by you, the government? Lakshman's was the honest Rekha. It was a spiritual Rekha. This is none of that. Number 2, the Congress, please consider the Congress in 60 odd years of rule. Please consider 15 years of non-Congress rule or 20 years. Tell me a single government of any color which in 5 to 7 years has misused it the way it has. Today, any satirist, there's a person in Rajasthan, Radhesham. There are so many instances we all know. You can't, when I was a student in England, we used to have not the 9 o'clock news. It's called Not the 9 o'clock news on BBC. The lampooning and the satire they did on politicians, sitting politicians, amazed me. Now, I'm not saying that you have the British standard of humor, which is very robust. I am saying that even the thought, anything remotely of making fun of an icon, you're going to be slapped with sedition. And you say, Lakshman Rekha, aap cross kar rahe ho.
And joining us right now is Senior Advocate in the Supreme Court and former Attorney General for India, Mr. Mukul Rohtagi. Mr. Rohtagi, thank you so much for joining us. First of all, your opinion on what the Supreme Court has done. It's being hailed as historic.
I think the Supreme Court has taken a very bold step. You see, this controversy of the validity of a pre-independence law has been raised time and again. The last time when the Supreme Court upheld the law was about 60 years ago in Kedar Singh's case. In the recent past, this law, if I may say so, has been used and repeatedly abused by various police and other agencies spread over different states in the country. Please understand that this is an old colonial law which was brought in by a British imperialistic regime when India was not independent. The idea was to suppress the natives who should not collect together to form a group to undertake a violent revolution to kind of overthrow the government by violent means, to keep the natives in place and the fear of God be instilled on them. This was the background of this law. So again and again this question arose, but in the last 10 years, this question has become very relevant because of a rampant misuse. Now, when this question has now arisen, and I wonder that you see, this law has been there for more than 100 years, and in the last 75 years of independence, I have rarely come across an important case or a substantial case where sedition has been proved. I mean, the center's affidavit in the Supreme Court talks about 6 cases from Assam. I don't know what has been the result of those cases finally, whether appeals are pending. But more than 300 cases or 500 cases have been filed against various persons, including some, political leaders and MPs, etc., where sedition is readily invoked. It's a very, very serious offence. It's a very serious offence, can be punished with death, and it is being used, in a very light manner without understanding what
So, Mr. Rohtagi, how would you respond to the government? And, this seems to be some sort of a flip-flop that the government has been doing in the Supreme Court. First saying that, we think that the law is fine, to then saying that we think we should place this law under review. Then when the Supreme Court said that should we keep the cases in abeyance, they say no, they should not be kept in abeyance. Do you think that the government has to be clear?
See, let me tell you, traditionally, every government always generally supports a law which has been made, whether this or any other law. Take Article 3, Section 377. Now that was also supported. In fact, I was the lawyer after I debated office. I started that case in the Supreme Court challenging Section 377. But this is the first time, and I say that the government stand is welcome. It is wholesome that the government reported that the Prime Minister has said that it is necessary to have a relook. That shows that the government is not being cussed about it, that we will oppose anything, you see, which comes against the government. I welcome the government stand. It is equally bold. The court stance is equally bold, that the law is suspect and therefore stop the operation of this law till you come back after a review at your own end. I mean, I would welcome both the steps with equal wholeheartedness, the government stand and the stand of the court.
Okay, but Mr. Rohtgi, my final question, you also saw the stand of the government, the law minister, who says that we must respect the Lakshman Rekha. Now the big question is that who's violating that Lakshman Rekha all this while? When you look at poor conviction and you look at a record number of cases where arrests are made under this law, one really wonders who's crossing that Lakshman Rekha. Is the court wrong in deciding what it did today? What Lakshman Rekha do you think the Supreme Court crossed?
I don't think the court crossed any Lakshman Rekha. Courts have and judgments are there where courts have stayed or suspended the operation of laws, on much lesser grounds. On the ground also that a law cannot be made by a state legislature, can only be made by a center, or can only be made by a state, cannot be made by a center, or you have crossed, the parliament has crossed its bounds in making a law. There are many laws which have been stayed. I mean, it's nothing new. It has happened in the past. This matter is very, very serious. And when the other side, namely the government itself, is saying, and I submit very, very appropriately, you should not blame the government at all. They have been frank enough to say that we'll have a relook. Now, if you are going to have a relook, it is obvious that in your own mind it is also suspect. If that is so, stop it, because it results in deprivation of liberty. Now, liberty is, in our constitution, is the highest pedestal. So something which deprives somebody of liberty, and if that is suspect in the minds of both sides, that is the court, the petitioners and the government, obviously you will keep it in abeyance for 2-3 months, let people get bails, etc., subject to strict conditions, and the government come back. I mean, I don't think anybody can accuse the court of crossing any Lakshman Rekha whatsoever.
Sure. Mr. Rohtgi, thank you very much for your time, sir. Thank you.